Firstly, my learned sister cannot be hard to allude to any mistake as to the date, as the date was given in the presence of the three of us. It's not a date that was taken on our behalf. She was present in court. We were present in court. The date was given here in court. So none of us, regardless of the status of the post list, because we are not guided by a post list, we are guided by our diaries and the court file itself. None of us can claim or take advantage of the fact that the matter was not post listed for today. Even from my end, I had to verify and follow up with the court register. We have the accused here, assuming she was not here today on the basis of all that mistake, alleged mistake. I'm sure the prosecution will be very strenuous applying for her arrest. So it goes both ways. Secondly, Your Honor, we do not have the complainants in court. We do not have the witnesses in court. Yeah, the duty to attend court cuts both ways. The very same way the law imputes a duty on an accused person to attend court with consequences attaching. It is the very same way the law imputes a similar duty on the complainant and the prosecution to avail their witnesses on the date the matter is set for hearing. And I say so, not just from my own conjuring, but I'll refer the court to section 202 of the Criminal Procedure Code. The implications for non-attendance of a complainant are clearly set out in law. The very same way the law envisions adverse consequences to attach, including cancellation of bond and bail for an accused person who fails to honor a court summons. The very same way the law envisions consequences to attach, one of which is the dismissal of the charges. That is a clear reading of section 202. No sound basis has been advanced. The matter is already in court. We believe the matter had been processed through the office of the ODPP. We cannot be talking again of the matter being back to the office of the ODPP. I believe they had satisfied themselves with the evidence they had before preferring any charges. It will be a gross violation of my client's rights and abuse of court process if we were to dash people to court in haste, in hubris, and then reconsider the merit of the charges after the fact. I insisted, and I still insist, Your Honor, criminal process must enjoy some sanctity and decency. They should not be abused. to settle scores, in this case political scores, because it is very clear. These charges have already achieved what they wanted. So they are growing cold feet already. They are not bent to charge my client. So it can't be you charge first, reconsider later. That is abuse of criminal process. The proper use of criminal process is you consider the evidence first, consider the law, consider the circumstances, then prefer charges, not the other way around. That would be jumping the gun, and these are very clear cases of jumping the gun. You are in court for a hearing, and we are back to the investigation desk. So, Your Honor, today I'll be seeking and I'll be inviting you to consider Section 202 of the CPC. No valid reasons have been justified. No sufficient reasons have been justified for this adjournment. Your Honor, adjournment, in as much as it's a discretion of the court, it is a judicious discretion. It must be exercised on sound principles and the law. Adjournment cannot be exercised on a mere say-so of a party. They not dish out without reasons. The CPC envisions the proceeding of a matter on a day-to-day basis. And that tells it all. Criminal justice and criminal procedure envisions that matters should proceed expeditiously. And it will be a violation of the rights of the accused if you are to charge her and then drag her through court process, not for any fault of her own, through unnecessary and uncalled for adjournments. So I strenuously oppose any invitations to this. In fact, no reason whatsoever. No sound reason whatsoever has been put forth for you to exercise any discretion to adjourn this matter. The prosecution knew. The orders of this court were very clear. You rendered yourself at length in your ruling while giving this date. And this was a sensitive matter. The court did reckon that. And any player in this matter knew the sensitivity of this matter and the urgency of concluding this matter. So, Your Honor, I'll be seeking that you deny the adjournment. If they don't have, if the complainant is not in court, if they don't have witnesses, they can withdraw the case. But if they won't, I'll be inviting the court to acquit. That's all.
Well, this is my ruling. This matter is for hearing today. The date was given on 5th of May 2026. These were my words in giving the date. Quote, due to the stated peculiarity of this matter, I direct the same to be heard on priority basis. The matter therefore be heard on 15th of June 2026. End of quote. This morning, the prosecution has made an application for adjournment on two grounds. First, that the file is with the DPP for direction, and on that basis requested that the matter be mentioned in a fortnight for the DPP's directions. Secondly, that the matter is cost-listed for hearing tomorrow, the 16th of June, 2026, and not today. The application is vehemently opposed by Mr. Ndumia, counsel for the accused person. He raised a litany of grounds for his opposition. I bullet it as follows. 1. That the date was fixed on priority basis in the presence of all parties. That the prosecution has no witness in court as expected. 3. That the DPP, presumably by preferring the charge, had satisfied itself on the propriety of such charges and sufficiency of evidence thereof. Hence, the purported recall of the file by the DPP cannot be a basis for an adjournment. And finally, that the application for adjournment is not founded on any sound legal basis. As is the law, adjournment of cases is purely at the discretion of the court. First, it must be founded on sound grounds, and secondly, the court is expected and must exercise such discretion judiciously. My role is to determine whether the reasons advanced by the prosecution constitute sound grounds for this court to exercise its discretion in its favor. On the first ground, the police file is not in court on account that it is with the DPP for directions. I agree with the counsel for the defense that before the accused was charged, there must have been a satisfaction by the ODPP that the evidence in their possession satisfied the preference of the charge at hand against the accused, hence the decision to charge. A recall of the file, especially with the knowledge that the same is for hearing, to me cannot constitute sufficient ground to adjourn the matter. If any direction was to be made, it ought to have been made way before the date fixed for hearing. That ground fails at that. The second ground is that according to the cost list, this matter is scheduled for tomorrow. This ground to me is too frail to stand. The prosecution has not indicated the repercussion of the alleged confusion. The prosecution has not inferred, as I would have expected, that its witnesses have been bonded to attend court tomorrow. Notably, the court record is clear. This date was taken in the presence of the parties. The date is so clear in the file. I do not find the ground sufficient to result to this court exercising its discretion to grant any adjournment. In the end, I decline the application in its entirety. No sufficient cause has been shown to warrant this court exercise of discretion in favor of the application by the prosecution. I direct that the matter herein to proceed as scheduled. The matter to be heard at 10:30 a.m. today.
Yeah. Whereas we appreciate the gesture by my learned sister, I'll be opposed to the withdrawal of the charges under Section 87 for obvious reasons. But even with a withdrawal under Section 87, they can rearrest my client just outside here and they charge her afresh. it does not insulate her from subsequent rearrest and charging. Here, in view of your earlier ruling, a ruling that was clear, a ruling that was considered, I'll be making an application under section 202 of the CPC, which if you allow me, Your Honor, I can read verbatim. The provision provides that in a case which a subordinate, in fact, let me start it falls under part 4 of the CPC, and it defines procedure, criminal proceedings in subordinate courts. The provision provides in a case which a subordinate court has jurisdiction to hear and determine, the accused person appears in obedience to the summons served upon him at the time and place appointed in the summons for the hearing of the case, or is brought before the court under the arrest. Then, if the complainant, having the notice of the time and place appointed for the hearing of the charge, does not appear, the court shall thereupon acquit the accused. And I want to emphasize the word shall. It is couched in mandatory terms. It is not discretionary. Upon the court rejecting the adjournment, if the complainant, the witnesses are not in court, the court has no other option other than to acquit the accused person. Your Honor, the prosecution, the witnesses, the prosecution witnesses knew of the date, they knew of the place, they knew of the time for this hearing. So the case clearly falls squarely under the provisions of section 202 of the CPC. So with a lot of humility, Your Honor, with a lot of respect for the prosecution, she has done her best, but this is a dead horse which she can't flog anymore. I urge the court to acquit my client, let her be free, and let this be a lesson to the prosecution. Send a message. Indeed, it is the duty of this court under the new constitutional order to strike a rule, to strike a blow for the rule of law. Send a message. Criminal justice system should never be abused for ulterior agenda, which clearly has been the case in this case. I urge the court to strike a blow, for the rule of law. That is all.
By the prosecution seeking to have the matter withdrawn under section 87 of the CPC. Sorry. Which again is opposed by the land. Sorry, sorry for that. By the application by the prosecution seeking to have the matter withdrawn under section 87 of the CPC, which again is opposed by the learned counsel for the accused person, have been extensively referred to section 202 of the CPC. For clarity, section 202 refers to where the non-attendance refers to where there is non-attendance of the complainant, the place and time appointed for trial. It too envisages a situation where the accused is present at the appointed place of trial in obedience with summons. In this case, the accused person is present in court, the place appointed for trial. The complainant is absent. The prosecution cited no knowledge of the complainant on the place and date appointed for trial. Notably, and as earlier submitted, the witnesses who are not bonded, hence the knowledge on the place and time of trial is in doubt. In the premise, I find for the prosecution and I hereby allow the withdrawal of the matter under Section 87 of the CPC. The accused person is accordingly discharged under the section, cash bail deposited in court to be refunded to the depositor.
We agree.
Thank you.